man. More hot dog talk during the break. We saved the disgusting stuff for the break. Oh boy, Joey Chestnut slamming him down as only one can in America. So also as only one can in America is what's been going on with NIL and the rules and the laws and the this and the that. And my goodness, everything that's been going on here the last, literally 2 years. The initial rulings began, I think it was July 1, 2 years ago, and here we are 2 years later. There's more laws in New York, and there's lots and lots and lots and lots going on in the NIL space. With that, we're going to bring on Dan Greene from Newman and Lichstein, an associate there, a law firm in the area. And Dan does a lot of stuff with NIL. Thanks for hopping on today, Dan, to help us parse through this, because my goodness, this stuff can get confusing.
Hey, Brian, thanks again for having me on the show. As you said, it's the wild, wild west of NIL continues, and especially in New York these days, and happy to talk through it. All
right, so it was about a month ago the New York State Legislature passed this bill. Kathy Hochul signed it into law. I believe it was on Monday. Dan, so give me from your perspective, what is the main takeaway from this law, and specifically how it will affect a school like Syracuse?
Right, so this new bill amends New York's original NIL bill. And the two big things to take away from this bill is that it expressly allows schools to identify, facilitate, and support opportunities for its athletes to earn NIL money. And the second, the most flashy, noteworthy part of the bill is that it basically says that the NCAA can open an investigation or punish any school or punish for any NIL activity, including any activities taken by a collective or any other entity that's supposed to be supporting the school's NIL activities. Basically saying to the NCAA, putting in the law, saying that the NCAA can't punish us for not following their NIL rules, which obviously has would make the NCAA upset. And the passing of this law, I believe it was signed by the governor. It was June 30th. Is that just a few days prior, the NCAA came out with what they do occasionally are these NIL updated memos, which are kind of clarifying certain questions that people have in the NIL space. There were 6 points to this memo, and the last part, the sixth part says, we see that there's issues here with states passing laws saying that you don't have to follow NCAA rules. What does the NCAA have to say about that? And the NCAA said, well, you should follow NCAA rules instead of your state law, which is a problem for many different reasons.
And, you look at that. I'm going to imagine, Dan, here that, from a legal's perspective here, that state law would trump NCAA memo. Is that the case, or is there any scenario here where, the NCAA is saying, yeah, don't listen to that law, we're in charge here, would actually be the most important matter?
I mean, in classic lawyer terms, of course, I have to say it depends. Generally, and most of the time, state law does trump the rules and regulations of a private association. However, there have been cases where these laws have been litigated, and a court has found that law to be unconstitutional or invalid for any certain reason. So the general principle is correct, but obviously not 110%.
Do you think the NCAA, and this would be more hypothetical here, I guess, Dan, because realistically, who's going to care about this other than the NCAA, or I guess maybe a school in another state that doesn't have these laws? Do you see a scenario where the NCAA essentially makes a case of this, sues the state, and it eventually gets into the court system to try to be like, yeah, our authority here is bigger than the state's? Or are they, at this point, they keep losing Supreme Court cases whenever it goes that way? Is that not a winning hand for the NCAA at this point?
Yeah, a lot of people have questioned the purpose of including this last point in their recent memo. There's been a lot of lobbying on Capitol Hill pushing for a federal NIL bill, and the latest messaging coming from the NCAA has been, look at all these states amending their laws and making every state NIL law different and every possibility different. And we need something to govern this uniformly, and unless it gets out of control, before it gets out of control. That's one point here. Like, I really don't see the NCAA adding this one point in here to, unless to gear up for litigation. As a possibility, I don't see it. If I was putting myself in the NCAA shoes, I think I would add this point in here to try and scare some of the schools in these states like New York and other states that have passed these kind of bills like Oklahoma and Texas and Missouri and Colorado to think twice before they start going wild and directly recruiting and inducing and acting in any sort of way that would definitely be against NCAA NIL regulations.
Yeah, and I guess Dan Greene is our guest here from Newman and Lichstein, an associate at the law firm, a locally based law firm, but specializes in NIL. Dan, I think we've seen this, in everything in college sports, but specifically in the NIL scape. Like, the rules were meant, and we know the original intent of NIL, and it's already been stretched 10 ways to Sunday. Like, it's not what it originally was supposedly intended to resemble, and I don't think that's really a great surprise to anybody. Is that the main worry here? Is not maybe what the law says in the eyes of the NCAA, but how the new laws, I guess, could be stretched or taken advantage of?
Yeah, I mean, the NCAA the only person they can blame is themselves.
Yeah.
You had the Olson decision, and then the NCAA came out with their interim, they're still calling it the interim NIL policy, a few days later. It didn't really say anything, and it basically allowed schools and other actors in the space to do what they want until they got called out for it, really. And the funny thing, coming back to this whole state law versus NCAA rule point, is that in the original interim policy with the NCAA, they said, hey, if you're in a state that has a state NIL law, follow the state NIL law. And now they're kind of doubling back on that. So it's kind of funny the way it's been working here. And the NCAA is just playing catch up and reactionary. And I think they're kind of hanging their hat on getting a federal NIL bill up on Capitol Hill. And I wouldn't bet on that.
Yeah, and I'd say anyone I've had on, be it yourself, other lawyers, sports business reporters, honestly, run the gamut of anyone that's looked at this. It's kind of all ended with that you wouldn't bet on it. I guess, right, if there was a federal NIL law, in theory, it would supersede all of this, and I guess bring some conformity, which would be useful here, right?
Yeah, federal laws would be the law of the land in this case. Uniformity would be helpful, but at the same time, it's a free market, and every state has different ways they like to operate and different morals and different thoughts. So I mean, it can go either way. The problem with the quote unquote federal NIL bill is that the NCAA is going to want more than, it's really more than a federal NIL bill. It's anything NIL is kind of just a sideshow of it. It's more about the employment issue, the antitrust exemption. There's more to it. The NCAA is maybe using NIL as a guise to try and, accomplish bigger goals, like they don't want athletes becoming employees of the school. They really want to get an antitrust exemption, which would bring them back to have some sort of power, because right now their power and sway and legitimacy kind of dwindles every day.
They're not on a winning streak of any sort when it comes to court battles or power or anything going in their way. It is going against them in many, many ways. As Dan Greene of Newman and Lichstein is with us. And Dan, the other side of the law, you're right. This side is flashy, like, the NCAA, we're going to ignore them, and the NCAA saying, no. The other side is probably more important, really, on the day-to-day of it, right, that this is not allowing schools to pay NIL, but it's allowing them, right, to go to their NIL people and saying, hey, here's Dan on the football team. Maybe you guys should hook up with Dan. Is that the general gist of the other part of the law, or is it a little different than I'm leading down that path?
Yeah, it's kind of the question I've been receiving from people in the NIL space is that, does this law allow New York schools like Syracuse to just do whatever the heck they want in the NIL space? And the answer is unclear, because there really isn't what's the line that can and cannot be crossed at this point. people are taking it as that, schools like Syracuse can do whatever they want, but this doesn't mean that the NCAA can still try to sanction them for anything or sue based on the law or anything like that. I think obviously I don't know, but what I'm based on what the NCAA's messaging has been through their memos and their guidances and everything like that is that the line is recruiting and inducements. There seems like they'd be okay with schools getting involved, facilitating deals, and having collectives and everything like that. But once that line is drawn, crosses from the spirit of NIL, helping athletes, monetize their rights to publicity, to recruiting athletes to come or stay to your school, I think that's when the NCAA goes on high alert. So it's, some schools may see the state law and gotten excited and then saw this memo and it's like, well, maybe we should just follow the NCAA rules and, the state law, allows us to do things, but we don't want to be the first ones to get in trouble here if it ever happens. I can see some schools just being like Texas A&M right now, saw this memo and was like, hey, we're following the state law, we don't care. But there could be other smaller schools, like we have a lot of small schools here in New York that may, see the state law and see the memo and just be like, what, it's not worth risking anything. Let's just follow the NCAA rules as they're written right now.
Yeah, it'll be really interesting to see how it plays out. And if, I guess more importantly, if the NCAA is actually going to punish somebody in any of these states or try to and see what happens. So far, they haven't punished anybody about NIL one way or another. I guess the part, like day-to-day operations, like say at Syracuse or whatever, say, this will make this within the rules now, right? All right, Dino Babers can be told by his NIL types, hey, we got $1 million. How do you want us to divide it up, right? And Dino's can say, yeah, give 20 to this guy, whatever. Like, having conversations like that, my understanding is before would have been against the rules, but now something like that would be within New York state law.
Yeah, I mean, again, in I believe it was the October guidance from the NCAA, I think they said it's impermissible for schools to communicate with a collective regarding specific student-athlete requests or demands for compensations. You can say this athlete needs X amount of dollars in NIL money, but at the same time, the state law says you don't have to follow that rule.
No.
So, being a lawyer, I'm going to get a lot of heat for doing my lawyer talk here, saying, it depends, but schools right now in New York are going to have to make a decision about whether they're going to go full on and full speed ahead and take the New York law as a cover, or put on the brakes a tad and still follow what's going on with the NCAA rules and regulations as they've been communicated through their memos.
Well, we know that Syracuse University spent money lobbying for this law, so I think that can at least lead you in some direction of how they're leaning on it. But you're right, it is a degree of how far do you go, because you can use this to go a reasonable length, or you can use it to go hog wild and see how it plays out at the end. So we shall see. It's fascinating stuff, Dan. I want to ask you this before we let you go. What do you think is next in the NIL space? What is the main thing we need to watch out for coming down the pike next in regard to this? Is it, students as employees, things like that, or is that far enough in the future that we don't need to start thinking about stuff like that yet?
Yeah, I think you hit the nail on the head there, Brian. It's NIL adjacent, but athletes becoming employees of their schools, that's probably the biggest issue that's currently happening, and also in coming along in the very current future, along with potential revenue sharing. There's been proposed bills, I believe it was in California, about there being revenue sharing between the schools and its athletes. I think the revenue sharing, the employment, NIL, I think that all kind of goes hand in hand with how this is all going to work and the future landscape of college athletics as a whole.
All right, Dan, fascinating stuff. I'm sure we'll check in with you on this down the line, because my goodness, just when you think it's done, there's something new, and it's an ever-changing space. So thanks so much for your knowledge here for a few minutes. I'm sure we'll do this again soon, okay?
Yeah, thanks a lot, Brian. Appreciate it.
That is Dan Greene, an associate at Newman and Lichtenstein, who works heavily in the NIL space. And, yeah, we need a lawyer's help on this one, because, man, who could possibly know? Who could possibly know? A guy like Dan. That's why we have him on. Good to chat there. We'll take a break now. We'll talk about something else that's legal when we come back. Gambling. Results from everyone's picks last week before the long weekend. We'll tell you how the man and Mario did last Friday. We'll do that when we come back. After this, phone lines open as well at 315-437-7644. Much more to come as we roll along. It's QSportsTalk.com, ESPN Radio.